All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 24-5201. Susan Qashu, PhD, also known as Pamela L., appellant, versus Marco Rubio. Ms. Khan for the appellant, Mr. Walker for the appellate.
Good morning, counsel. Ms. Khan, please proceed when you're ready.
Thank you, Your Honor. May it please the court. During her fellowship at the State Department, Dr. Susan Qashu's supervisors ridiculed her disability, berated her when she requested help with her assistive technology, diminished her responsibilities, and did not renew her fellowship. I will begin with the non-renewal of her fellowship, which a jury could find was discriminatory. State claims that it rescinded Dr. Qashu's fellowship because she did not return her renewal paperwork on time and couldn't commit to remaining in the Office of Ocean and Polar Affairs. A jury could disbelieve both explanations. 3 pieces of evidence contradict State's missed deadline explanation. First, AAAS representatives in an email at JA 449 provided Qashu an extension on returning her renewal paperwork while they considered her proposed changes. Second, Qashu testified at JA 64 that she called each week to check in on the status of her paperwork. And third, State Fellowship Coordinator Jenya Dana informed Qashu that her proposed changes were approved at an email at JA 229 without alerting her to any missed deadline or risk to her fellowship. Given this ongoing dialogue, a jury could conclude that, a jury could disbelieve State's explanation that it rescinded Dr. Qashu's fellowship a few days later because she had missed the renewal deadline. Second, a jury could also disbelieve the State Department's explanation that it did not renew Dr. Qashu's fellowship because she could not commit to staying in the Office of Ocean and Polar Affairs. Dr. Qashu only sought minor proposed changes in her paperwork, which is at JA 226. She simply wished to change the reference to Dave Sawyer from mentor to point of contact / supervisor. And that change was ultimately approved in the same email at JA 229. So given the fact that at that point, the State Department, AAAS, and Dr. Qashu were all operating on the assumption that she was going to stay in the Office of Ocean and Polar Affairs with Dave Sawyer as her supervisor, a jury could disbelieve State's explanation that it rescinded her fellowship because she could not commit to staying in that office.
So there had been some back and forth about her switching offices though, right?
Yes, there was some testimony that in early June, Dr. Qashu considered switching offices or supervisors. But she, at that time, also was willing to commit to staying in the Office of Ocean and Polar Affairs, as she testified at J64. And at that time, she also tried to hand in paperwork, which kept her in the Office of Ocean and Polar Affairs. Because if you look at her proposed edit to the paperwork at JA 226, there's no edit to the statement that the second year of her fellowship will continue in the Office of Ocean and Polar Affairs.
So when you say at JA 64, that's where I should look to see indication that her perspective was, yes, first best solution is I'd like to switch offices, but second best solution is renew but stay in the same office. It wasn't as if it was being framed as I'd like to renew, but only if I can switch offices.
Yes, exactly. And that's the whole State Department's whole argument, that she was either wanting to change offices or supervisors or not continue her fellowship. But that's really contradicted by evidence in the record. I mean, she testified that she was willing to stay in the Office of Ocean and Polar Affairs from the beginning because she loved her ocean acidification work. And that's at JA65. Where she testified that she was willing to stay in the Office of Ocean and Polar Affairs. And even one of the supervisors that she sought to change to, Julie Gorley, was also in the Office of Ocean and Polar Affairs. So there's just no evidence that she was so intent on changing offices that she would have, preferred to, I guess, not to do the fellowship at all. And also by the time of the July 12th email, there's clear evidence in the record that she was willing to stay in the Office of Ocean and Polar Affairs because the only change she requested was changing the reference to Dave Sawyer from mentor to supervisor / point of contact. And in order for Dave Sawyer to have been her supervisor, she would have had to be in the Office of Ocean and Polar Affairs because that was where he was situated.
Where do you think it gets you if we think that there's some doubt about those two rationales, the one being you didn't submit your paperwork in time, and the other being you wanted to switch offices, but you're not going to be able to switch offices.
Yes, so this court said in Aka versus Washington Hospital Center that evidence from which a reasonable jury could conclude that an employer's proffered explanation is false can be enough to get the case to a jury, because the fact that a employer hid their true explanation suggests that they have something to hide, and that something may well be discriminatory intent. But here we also have independent evidence of discriminatory attitudes on the behalf of decision makers, on the part of decision makers.
So before we go to that, I do want to hear what that is in your estimation. But before we go to that, if we just put that to the side for a second and suppose all we have is the two proffered justifications, and then in your mind, neither of those holds up. Where does that leave us vis-a-vis summary judgment? That alone.
Yes, so that would allow you to send the case to a jury, because a jury could infer from the fact that the State Department's proffered explanation is not the real one, that from that evidence alone that there was a discriminatory motive. And because we're in a situation where, you know, the State Department has been accused of discrimination and are providing an explanation in that context as to why they took these challenged employment actions. And so if their reason for the challenged employment action turns out to be false, I think a jury could infer from that they, like I said, they have something to hide, and that something.
But a couple of times you said that we could allow it to go to a jury, but do we have to, or what factors into it apart from the evidence that you think independently shows that there was potentially a discriminatory?
Yes, well, so I think this court said in G. Jesus versus Washington Post that it's not an easy answer, because in Aka versus Washington Hospital Center, the court essentially said, like, there's no concise and generic way to condense under what circumstances the evidence calling an employer's explanation into question is enough to go to a jury. But I think here what you have is both the prima facie case, which is the fact that Dr. Qashu was terminated from her is a member of a protected class and was terminated for a reason that was neither that she wasn't successful at her job, because that was never in the record, and not that she that her position was eliminated, which are the two most common reasons that an employer will eliminate a position. And this court said in George versus Levitt that that's enough to show a prima facie case. So you have that evidence plus the State Department's reason being called into question by evidence in the record. So I think those two things together are enough to send this to a jury. But as I said, there's
something about the shift gears a bit if you're ready.
Yeah.
On accommodation of her handicap, disability, I should say. I don't understand how we could take into consideration anything on that score that predates her saying it was great, everything was wonderful.
Well, Your Honor, I think
to wash out whatever predates that.
Well, I have two responses to that, Your Honor. So first of all, when she said that everything was stupendous and fabulous, she was only referring to the accommodations that come from the Disability and Reasonable Accommodations Office.
All the computer stuff, the equipment, all of that.
Yes, but it doesn't have anything to do with, for instance, her move to a quieter office, because her supervisors in OPA were the ones who had the purview over whether or not she could change her office.
Well, there's a lot in your brief about equipment.
Yes, there's a lot in
A lot of it predates the relevant statements.
Yes.
Can't we just disregard that? I mean, I was taking, grant you if there's other things that post-dated that aren't covered because they weren't part of the equipment GRAD provides.
Well, no, I think the fact is that this email does not conclusively show that she was fully reasonably accommodated. I think the email that you're referring to is the exchange with her supervisor, Shever Voltmer, in which Voltmer said, basically where Dr. Qashu said, I'd like to have a meeting with you in the office of DRAD. Would you be willing to do that? And Voltmer said, I'm too busy to do that. So is that really, essentially, is that really necessary? What?
What was the date of that?
September 2016.
Which is after the statement.
Well, no, so I think this statement is a part of an email exchange with the office of DRAD, because it's at, I think it's at JA 195.
And the date on it?
Oh, sorry, it's, so it's at JA 196, and it's part of the exchange that starts at JA 195. And it's dated September 23rd, 2016. And basically, you know, in the context of this email, Shever Voltmar had asked whether, you know, there was some support that Dr. Qashu needed from the office that she's not getting. But the tone of the email was that she didn't want to, like, I don't really need a meeting. She didn't really, wasn't showing a lot of enthusiasm toward meeting with Dr. Qashu. And so my point with all that is just to say that at this point in September, Dr. Qashu had been experiencing hostility for requesting reasonable accommodations for months. And so at that point, I think a jury could.
I can't hear as fast as you're talking.
Sorry. And so I think at that point, a jury could conclude that at least one interpretation of this evidence would be that Dr. Qashu didn't feel comfortable asking for additional accommodations at that point, given the hostility that she'd faced, and also because her supervisor's email indicated a reluctance to meet from the beginning. And so I don't think that it conclusively shows that all of her reasonable accommodations were completely adequate at that time.
And on the moving the office, that was about the noise, isn't that right?
Yes.
So she was given the headphones early on,
Yes. So
long before she said everything was great.
yeah, so I think that that indicates that the headphones weren't enough to block out.
What is there on the record to say?
Yeah, so at JA 250, well, first of all, just to take a step back, so she was given the headphones from the first day of her employment, which was February 7th, 2016. And she states in her declaration at JA 257, or sorry, JA 255, that she first sought a move to a quieter office in March 2016. And so at that point, she already had the headphones since, or not, sorry. Sorry, I meant to say JA 273. As she states at JA 273 that she started asking Sawyer for an office accommodation in March 2016, but she'd been given the headphones on February 7th, 2016. And so she already had the headphones when she was making the statement that her office was too noisy for her to hear the assistive technology. And earlier on in that same declaration, she says that she would wear her headphones every day. And so I think that that could have visibly signaled to her supervisors that her headphones were not enough to block out the noise of the printer, scanner, machine, and the noise of her other colleagues talking. So I think that the headphones the really key point here is that no accommodation was given to her after she asked to move to a quieter office. The headphones were given to her before, but I think any supervisor could understand that if she's asking to move to a quieter office because she can't hear her technology, like that the accommodations she already has aren't fixing that problem. And you also see that at JA 267 because she's stated that she has to stay until 10 p.m. at night to finish her work because she couldn't hear.
On another score, failure to promote her is the way I think you put it in the brief. This isn't mentioned in the complaint. Only the demotion that shows up in the alleged demotion that shows up in the complaint. And so the district court didn't deal with separately with failure to promote. And I'm not sure it's a promotion, right? There was no change in GS level for Oak or whoever it was who got the position that she would have liked, or that you're saying she would have liked, right?
Yes.
Okay, so there was nothing in the complaint about that. The district court therefore didn't deal with it. When asked whether she wanted to take the lead, which is all this is about, not her position, but the portfolio, some responsibility for that portfolio, she demurred.
Well, okay,
I don't
so
see how she can complain about not being chosen when she expressed no interest in the position.
well, so okay, so
Directly asked and expressed no interest. And neither did Bogue, right? Neither of them did. So the supervisor, I think, was good, was in that case, Evan
Bloom.
Bloom, thank you, had to make a decision and made it.
Yeah, so I have two responses. So the first response is that at JA 291, Dr. Qashu said that she met with Shepard Voltmer, her supervisor, and Voltmer supported her continued primary role on the portfolio and said that she would run that past Evan Bloom. So I think from that, this is a dispute of fact. Like,
All right, and then the upper level supervisor decided the other one.
yes, but I think that a jury could find it discriminatory that the reason that state, or could disbelieve state's reason, because it said that the reason that it didn't give her this role is because she didn't ask for it, but there's evidence in the record that she essentially did ask for it by speaking with her supervisor and asking her to check with Evan Bloom about whether she could continue in a primary role. And then my second point is that,
Do we know that Voltmer ever did that?
well, Voltmer said that she never gave any recommendation to Bloom in her affidavit about who should take on the lead. But I think that,
So as far as Bloom knew, she expressed no interest. The intermediate supervisor had never said anything one way or the other.
well, first of all, I think so. First of all, there's a dispute of fact because obviously Voltmer says she never said anything to Bloom, but Qashu says Voltmer told her that she would check with Bloom. So that's a
Those
dispute.
aren't inconsistent. We
Um,
told her she would check with Bloom, but it turns out she never did.
well, yeah, I guess, but I think that it could be inferred that if she told,
There are a lot of inferences going on.
yeah, well, my other inference
You're
is,
entitled to some inferences, I grant you, but not infinitely.
right, but I
So
think,
what about the problem that this wasn't raised? That the failure just wasn't in the complaint? In fact, it wasn't in the proceedings in the district court. It just shows up in your brief, different counsel, different arguments. That's not really quick, is it?
well, I think that definitely in the complaint at J206 at 103, and this is kind of dovetailing with my second point, that regardless of whether you call this a demotion or a promotion, our key argument here is that her responsibilities changed significantly. And that's in
Hey,
the,
let's deal with that. Responsibility has changed. Why, what in the statute says a change of responsibilities is sufficient to make out a case?
well, I think that some of this,
Are the responsibilities a term or condition of employment?
yes,
Really?
well, I think that
The
here,
responsibilities within a job? She did a lot of different things. Her evaluation lists about 6 different things that she was involved in.
yes, but I think that this court, or the Supreme Court said in on call that like terms and conditions aren't just reduced to what is a part of the contract. And this court said in Chakowski versus Peters that a significant diminishment of responsibilities can be adverse to permit a claim under Title VII, and like we're using the same standards here. And then also we just had the Supreme Court case Muldrow, where the key argument was a change in responsibilities because Jatanya Muldrow was moved from one role to another without being demoted, and her key argument was that her
Right, but
responsibilities.
You need some harm,
Yes, you need some harm. Yes.
And a change of responsibilities.
Well, here we have, I think we do have some harm.
I think it's also a material adverse action.
I think a jury could find it to be a material.
Really? It's even that? Not just, okay.
Well, okay, so
Swinging for the stars here.
well, no, I think that at JA 524, you really get a good sense of what her responsibilities were prior to the switch and Bach taking over on October 25th, 2016. And so prior to Beck taking over, she collaborated with interagency partners to run a conference in Helsinki on ocean acidification, provided expert technical advice on the topic, developed and reviewed calls for ocean acidification proposals, and then also spoke at interagency meetings and on behalf of the State
Which
Department.
she continued to do apparently, right? At least through her emails.
Well,
She is still involved well after all.
well, so at JA 257, she explains how her duties changed after the like Beck taking over, and she states there that she was essentially reduced to a clerical role, that she could not speak on behalf of the State Department without Beck's permission.
An estimate of how much time she spent on that portfolio?
Yeah, so her performance review says that she spent a considerable amount of time on it, and then at JA 524. And then if you look at the narrative description of what she did during her whole fellowship, it's almost all ocean acidification work. So I think from that, you could infer that at least for
524 that I'm looking at. He engaged in a diverse range of ocean-related issues over the last year. Also worked to advance efforts to expand global ocean monitoring through the Global Ocean Acidification Network. Staffed and the second World Ocean Assessment, separate issue, separate portfolio. More broadly, made her expertise available widely within not just her office, but also the Bureau at large. Also worked with regional bureaus and other parties on a wide range of ocean issues, including maritime debris and pollution, Arctic invasive species, and other ocean conservation. So she was doing a wide range of things related to her specialty.
Well, I think a jury could infer from this that because the first sentence is a considerable amount of her time was spent advancing department efforts to combat ocean acidification.
Yes, that's a fair inference. I mean, that's on the page, but I'm not sure why that supports an action.
Well, so just to go back though, I think it's important to understand that, after Beck took over, her duties changed drastically, or at least there's a dispute of fact over whether they did. So I think that this is at least a jury question as to whether her responsibilities were significantly diminished, because she says that she was reduced to a clerical role which is different from a role in which she provides.
Well, that's what's said, but then after that, she's engaged in these emails. She clearly was doing more than just supporting Bogue.
Well, those emails were, even under her own explanation of how her role changed, she did say that she could communicate with Beck's permission. And so it's possible that there were a few emails that Beck permitted her to send. And one of the key emails is about the conference in Helsinki, which everyone agrees that she took the primary lead on. So it may have been a kind of grandfathered in that she'd already worked on that conference. But generally, I think there's a dispute of fact here over whether her roles changed significantly, because she went from, as I said, running a whole conference in Helsinki and providing, speaking on behalf of the State Department in interagency working group meetings and also in staff meetings, to a role where she couldn't even speak in staff meetings on this topic at all without Beck's permission. And so, I think any reasonable.
As far as we can tell, Beck just gave her blanket permission, because there's no instance where she was, that we know of, where she was muffled. Thank you.
I have just one final question on going back to the disparate treatment and non-renewal. So you were going to give us a quick list of what the evidence is from which not just that the proffered explanations were pretextual, but that there was discrimination at work. And I'm just going to give you a chance to do that, but to focus on indicia that in fact indicate discrimination based on disability, as opposed to maltreatment because the bosses were just not very charitable people.
Yeah, so there are three basically groups of evidence that I'll highlight. First, the affidavit at JA 300 from Alicia Cahoon, a reader who worked regularly with Dr. Qashu. And she declared that based on her experience working with Dr. Qashu, that management also seemed to resent the fact that people from our office were coming to assist Dr. Qashu, and that someone had to be at the front door to let people from our office inside. The managers at DOS, which is Department of State, seemed to require reasonable accommodation for her as an imposition. And then later on at paragraph 8, she states that I also noticed that other employees were frequently treated better than the employees with disabilities with whom I worked. So that's one piece of evidence. The second piece of evidence is the evidence related to Sawyer, Qashu's first supervisor, who berated her when she was using readers and when she was trying to set up a printer to work with her assistive technology, said, don't you see that people have better things to do, which could indicate that spending time on reasonable accommodations was a low priority for the office. And then he also engaged in pelvic movements whenever she was in his presence, which he did not do to other employees without disabilities, and she testifies that at JA 71. And that appeared to be a way to exploit her limited eyesight because, I think a jury could infer that that was a way of exploiting her limited eyesight because he assumed that she couldn't see those derogatory gestures. And then third, I'm
not quite following that one, because it would be one thing. I don't understand why that's discrimination based on disability, even if it's true that for somebody else to do the same kind of behavior, they'd have to have their back turned.
Well, I think it's because it's taking advantage of the disability and sort of amusing himself at her expense, knowing that she has limitations that like sighted individuals don't have. And there's also the fact that she testified that he didn't do this to non-disabled employees, which is a disparate treatment. And then also it's sort of like if you had a deaf employee and you said things in front of them that you knew they couldn't hear just for the purpose basically of like exploiting their disability at your own, for your own amusement.
Mhm.
Yeah, and then our third piece of evidence is related to Bloom, Dr. Qashu's second other supervisor, like higher up supervisor, who would turn his back whenever she was in his presence, which this court has said can show discriminatory attitude in Tchaikovsky versus Peters, and then also did not respond to her complaints about the derogatory gestures of Sawyer.
Let me make sure my colleagues don't have.
Can you help me understand who made the decision on the renewal? There was AAAS, and then there was State Department. I take it those are two different entities. And can you help me understand that better?
Yeah, so I think that they made the decision together because the State Department has admitted its involvement in this decision, at least as to the staff's office, which is like the fellowship coordinating office. And then also, I guess there's a dispute of material fact over whether Sawyer and Bloom were involved in the decision, but there is evidence in the record suggesting that they were. So for instance, AAAS, before making the decision not to renew Dr. Qashu, called Sawyer to ask for his and Bloom's point of view on this, and this is that's at JA375. And then also the AAAS 30B6 deponent testified at JA414 that if the host office and the fellow agree and both wish to seek a renewal, that AAAS wouldn't upset that decision. So that suggests that the State Department was involved.
Thank you.
And there's also, I guess, one of the letters at least speaks in terms of a three-way agreement. And I mean, there's obviously a question that later emerges about whether Qashu, in fact, was on board, but the other two legs are AAAS and state.
Yes, yes, that's right. And that letter at JA452 also references discussions with the host office as producing the decision not to renew.
We'll give you a little bit of time for rebuttal. Thank you, counsel.
Good morning.
Walker.
May it please the court, Johnny Walker for the Secretary of State. Your Honors, the Department of State welcomes disabled employees and expends significant resources to ensure that there is success at the agency. For Dr. Qashu, the department did that. On day one, when she began her one-year fellowship in 2016, it had acquired for her nearly a dozen different technologies and tools to accommodate her central vision loss. It provided her a desktop computer loaded with a software that can both read text out loud and zoom into the text, separate software that could also read out loud the text, a laptop computer with both of those same softwares loaded onto it, an extra large monitor with an arm that she could use to extend it towards her face, a closed circuit television that she could use on her desk that she could put hard copy documents on, which would both magnify those documents and read them out loud to her. It also gave her a handheld device that she could take around the office to magnify things like displays on shared office equipment and door numbers, as well as change the contrasts of those so that she could see them more clearly magnified. It also,
So most of this goes to the accommodation
Yes.
part of the case, and I know that that's been a meaty part of the briefing. But if you could start with where the other side started, which is on disparate treatment
sure.
and the non-renewal. So as I read the ultimate decisional document, which is at JA 231, the first consideration mentioned is that there was a deadline to submit signed renewal paperwork passed more than a month ago. And then the next one is that your request to change offices and mentors is not approved. There's some stuff in the middle about fit and things like that. It doesn't sound like there's a whole bunch of reliance on that from your perspective, understandably, because that might just dovetail with the office switch, but it sounds like that's what you think. But in terms of the signed paperwork being more than a month ago, which is the first thing that's stated, it's just, she did try to sign it.
There's the record shows that she signed it and had it in her possession to turn in. But I think the key is that she consistently indicated her unwillingness to rejoin the office where her fellowship had been renewed and to be supervised by the deputy director of that office. And what you see consistently in the
Which
communication.
deputy director?
This is so here.
But I thought she was trying to clarify is that he was her supervisor.
No, I mean, she says in her deposition that she wanted to change supervisors and she wanted to change offices. And she was continuously raising these concerns with the central office at the Department of State that makes these decisions, Ms. Dana.
Did she not say, I'd like the letter changed so that it reflects that Sawyer is my supervisor, not my mentor?
She did say that, and eventually Ms. Dana, reached out to her and said, I want to help understand your concerns with renewing with the Office of Ocean and Polar Affairs. Ms. Qashu took over a month to get back to her, and eventually did. And then Ms. Dana responded that they would change Mr. Sawyer from her supervisor to her point of contact. List him as, I'm sorry, instead of mentor, they would call him a point of contact. And Ms. Qashu, again, all this time, she's raising additional concerns about renewing with that office at all, saying that she didn't feel she was a good fit in that office and that she didn't want to be supervised by the person who is the deputy director of that office and is responsible in part for running the office. And so after Ms. Qashu doesn't respond to Ms. Dana's email, changing the designation of Mr. Sawyer for over a week, AAAS sends her that letter saying that her fellowship is not being renewed, that her request to change offices was being denied.
So this entire explanation in your mind then turns on the notion that there's no reasonable dispute of fact on whether she would only accept renewal if her office was switched.
I think that, I don't know that we can get quite that far on the record that she was firm that she would absolutely not. What she was definitely doing was raising concerns about the office that she had been renewed with that made the central office at State, Ms. Dana, unwilling to process her renewal and accept her and renew it. There seems to have been a mutual concern about her fit in the only office that the Department of, or I shouldn't say a mutual concern. There's a concern being raised by Qashu, which causes a concern on the part of the Department of State about Ms. Qashu being able to fit with the office, the only office in which she is being offered a spot. So I think that the explanation here is broadly consistent. She's definitely raising those concerns. There's no dispute about that in the evidence, and the Department of State is not renewing her position in the Office of Polar Affairs because she consistently expresses those concerns and does not retract them and explicitly accept the position of the office.
So your view, I guess, is that she had expressed concerns about her current station. She might not have conditioned her renewal on switching stations, but from State's perspective, she was concerned enough about her current station that that indicated a lack of sufficient commitment to the current station. And so then State thought, okay, look, you've said you're willing to sign. That's undisputed. This can't be about the paperwork of signing. That just seems like that's not possible. But what it indicated was you're not really that happy with where you are. And if you're not really that happy with where you are, then the fit just isn't good enough. And so we're not going to renew. That's kind of the way that you're.
I think that's the way I'd put it. I don't think we see her explicit, Ms. Qashu, I don't think we see her explicitly conditioning on that, but she's certainly giving that impression with the concerns that she is raising.
I see. And you think that's sufficient? There's enough of a clear indication of that in the evidentiary record that a jury couldn't conclude otherwise in terms of whether that's the real reason.
Well, I want to back up a little bit. I'm just talking about the fact that I think the record is quite consistent. Even if you could draw the types of inconsistencies that my friend is drawing, they don't go so far as to demonstrate discrimination, right? This court's case law is clear that it's not enough to show the employer's reason to be pretext. And as I say, I don't think there's any indication of pretext here. It also has to show that the real reason is discrimination.
I don't think that's true at summary judgment.
I think what ACCA says is that there are times when the employer's explanation is so false and so disbelievable that it gives rise to a discriminatory motive, that this is far from that circumstance. And I think this court has said.
But that's the government's view, is that if the employer puts forward, if the government puts forward one explanation and that explanation is disproved, it has to be so false that it could be discrimination. Even if it's the only explanation that's given. I don't read the case
I think I read ACA as saying it does have to be, there are circumstances in which the explanation is so false that it gives rise to an indication of discrimination. And then the pretext cases say that an employer must show that the employer's reason is pretext and that the real reason is discrimination. But I think, as I say, I think here, it doesn't come close to such falsity that there's some discrimination perceived here, and there's no pretext. And so what my friend does is try to rely on other indications of discrimination that she went through. Most of those relate to actions by Mr. Sohier and Mr. Bloom, the director and deputy director of the Office of Ocean and Polar Affairs. And but the reason that those don't work here is because they both supported renewal of Ms. Qashu's fellowship consistently. And she indicates that, I mean, my friend indicates that there was a call between the central office, I'd say, I think it's the Office of the Science and Technology Advisor to Mr. Sohier. But what Mr. Sohier testifies that call consisted of is that office asking if Mr. Sohier would be okay if that office decides not to renew Ms. Qashu's fellowship. So there's no indication of a cat's paw where Mr. Sohier, while indicating that he supports the renewal, somehow influences the central office to not renew it. It's quite the opposite. They check in with Sohier and say, we know that you support the renewal of the fellowship, but we want to withdraw it. Would that be okay with you?
She took, if I understand right, she took a month to reply to an email.
Correct.
Do you think that, why isn't that alone a fireable offense, or at least a reason enough not to renew someone's fellowship?
Yeah, I think it is a building block in this picture you have of the State Department. It had renewed Ms. Qashu's fellowship, let's be recalled. It renewed it. It sent her a letter saying, congratulations, Dr. Qashu, your fellowship has been renewed with the Office of Polar Affairs. Simply accept it. And what you have is a consistent string of events after that of her indicating that she did not want to work in that office, indicating that she did not want to work in with that supervisor, and taking over long to respond to emails and communications when she had been given a deadline. Now, she argues that her deadline had been extended indefinitely, but that's not what the email records show. I mean, she said that I'm going to be on vacation next week, and she's told we can certainly take up this issue next week when you return. But she's never told you can turn in this paperwork whenever you want indefinitely into the future.
Do you agree with this? A reasonable jury could only conclude that after someone is given a week-long extension of a deadline, misses that deadline, and blows past it by an entire extra month, that the employer has a non-discriminatory reason to fire that person.
Yes, absolutely. And it's not a termination here, right? It's nothing so dramatic as that.
To not renew their fellowship.
Yes. I would agree with that. And I agree, particularly when you look at it in the broader picture of the concern she's raising. It's even more less.
The letter saying congratulations also said you have a week,
Correct.
right, to return this, and then extends it that at least for the week she would be away, at least. Right?
That's correct. Nobody ever says she has an indefinite forever extension to return.
So where do you see the stated reason being that you took too long to respond? Where's the indication that the reason she didn't get the renewal is because she took too long to respond? Is that coming from the fact that the letter says the deadline passed more than a month ago?
The reason is it's in the, I believe it's a June 19th letter from the director at AAAS that indicates that she did not accept replacement within the Office of Polar Affairs in a timely manner. And it also mentions that there's not a good fit and that her request to change offices is
So it's that letter. Then that has to be from the line that says it passed more than a month ago.
Right.
Yeah, even though it's clear that they didn't care that she didn't respond more than a month ago.
Perhaps not independently, but it's all mentioned in this letter as part of a broader reason. You did not timely accept the offer that we provided you. You're consistently raising concerns about renewing with the office, the only office that you've been permitted to renew in, and working with that supervisor. So I think this all fits within the same narrative, and there's nothing contradictory about the time that she takes to sign the paperwork.
Yeah.
And maybe I'm a little confused on what was going on in the month. Was it kind of constant back and forth between her and the people who were deciding what the next year's fellowship would look like? Or was there a period of several weeks up to even a month where they just didn't hear from
The record makes it look like there was a period where they did not hear from her for a month.
She
Or
ghosted.
at least she didn't,
She ghosted.
gave no indications that she wanted to accept with the Office of Polar Affairs. I mean, she testifies, I think, in her deposition that at some unspecified time, she was calling and leaving messages with them. But she also testifies that she was inquiring about her request to change
Was
offices.
there someone who either emailed her or left her a message that she didn't reply to for about a month?
There's no indication of that. I mean, except for the email that we have in the record that she did not, from Miss Dana, that she did not respond to in a month.
And what was there any indication, what, she did indicate at one point, I'm happy to come in and sign, right?
Yes, but not to renew with the Office of Polar Affairs. She's still during that period raising concerns about the office to which she has been
But
assigned.
did she say that in that part where she said, I'm happy to come in and sign? Did she say if it's with a different office? We don't, or was that, which agnostic as to that?
But we know at that time that she is still raising concerns about working in that office. So she did say she's willing to come in and sign, but like afterwards, we still have communications with her where Miss Dana is trying to address her concern about renewing with the Office of Polar Affairs.
No, I understand that, but I'm just saying in the part where she says, I'm happy to come in to sign, if the timing is going to be an issue, I'm happy to come in to sign. Is there something in that communication that indicated a condition on her part? That, of course, that means I've raised some concerns about the office. And what I mean by that is I'll come in and sign. I mean, obviously, if you switch offices. Is there, I'm not saying that you have to have that. I'm just wondering whether that is the way that you think we should infer that, or is it different from that? I'm not trying to say what you need to establish to prevail. in
Right.
Getting an affirmance. I'm just wondering how you think we should understand that communication.
I think you have to understand it in the whole context. And you have the next month in July, this is at
And the whole
JA.
context meaning you, the way you understand that is, I'm happy to come in and sign. But of course, I've been raising questions about an office switch. So what I mean by that is, I'm happy to come in and sign, you know, if you switch offices like I've been asking.
Right. I
That's the way you
mean,
think we
because
should.
those concerns are still being voiced, and she's still voicing them on July 7th at JA 229. She's still saying, I will not sign off on paperwork that lists Dave Sohier as my mentor. He is not my mentor. And then she says, and then Miss Dana responds to that. That's July 7th. Miss Dana responds July 12th that change will be made. And she never responds. So on July 19th, she gets the letter from AAS saying, look, your request to change officers and supervisors is not approved, and we're not withdrawing the renewal offer. Any further questions?
Is there, I guess, from State Department's perspective and for the purposes of the form, what's the difference between a mentor and a supervisor? I recognize not all supervisors are good mentors, but it seems like mentoring is usually part of the job description for supervising.
It is. It seems to have been a term of art that was used in connection with this fellowship. So I think most fellows would be assigned a mentor, and that mentor was typically designated by the Department of State, by the host agency. So
That makes sense.
Thank you, counsel.
thank you. Please affirm.
Don, we'll give you 2 minutes for rebuttal.
Thank you. I'd like to begin with JA 229, which is the email in which, JA 449, which is the email where Dr. Qashu said that she would come in to sign the paperwork. So on June 7th, 2016, Dr. Qashu wrote the following email. She said she renewed her membership, et cetera, et cetera. Then she said, Dave Sawyer is the supervisor, boss. Dave Hogan is the mentor. Not sure which one you need to list at this point. If you need any paperwork signed by tomorrow, since I did not receive it via email, I could come by the AAAS office and try and sign it. And so from this email, I think a jury could conclude that she was willing to submit signed paperwork, keeping her in the Office of Ocean and Polar Affairs, because as I said before, for Dave Sawyer to be her supervisor, she would need to be in the Office of Ocean and Polar Affairs because that is where he is situated. And then also, Judge Walker, to your question about the difference between a mentor and a supervisor, the AAAS deponent testified at JA 408 that a mentor is not the same thing as a supervisor. And like a mentor is someone, this is at J408 at the bottom of the page. The mentor is someone who's going to be providing some general guidance, answer questions, give input. Sometimes mentors and fellowship host office supervisors are the same person. That's not always the case. And so here, I think what we can take from the combination of these two emails is that she was willing to commit to Dave Sawyer being her supervisor and her staying in the Office of Ocean and Polar Affairs as early as June 7th. And then meanwhile, in the interim
Could only
period.
Supervisor, yes, okay, but not mentor, that's the point.
Yeah.
Okay.
And then, and that's that, yeah. And then the other point is that she testified at J64 that she was calling every single week to like check in on the status of her paperwork. So from that perspective, even though she hadn't responded to the email, I think a reasonable person could, yeah, so sorry, so this is at J64 and it's near the top of the page. She says, so I was reaching out every week or so. And so from that, even though she didn't respond by email, a jury could infer that she was following up through other mediums of communication. The last point I'll make is that the July 12th email, once again, does not suggest in any way that she's missed any renewal deadline or that there's any risk to her fellowship. It just says that her change to change the reference to Dave Sawyer from mentor to supervisor is approved. So at that point, everyone agreed that she could continue in the Office of Ocean and Polar Affairs with Dave Sawyer as her supervisor, which is what she's been asking for from the beginning.
What's your response to the notion that, look, it's not that there was some formal idea that you had to sign by a particular date and you let that date slip. It's that we sent you a letter that gave you an opportunity to sign off on renewal. You've raised some concerns. There's concerns that you've raised for some time about not being happy with where you are and wishing that you could switch to a different office. We sent you a letter. Really, I mean, you've raised a couple of things and we've tried to address those, but there hasn't been a great deal of responsiveness on your part. As a general matter, it just seems like you're not happy enough to be where you are that we're willing to go forward with the renewal because we'd like to have a situation in which there's a commitment to the task at hand. And that's the best way to read the July 19 letter is that, yes, you missed the deadline, but what we mean by you missed the deadline is that you missed the deadline, you got past the deadline, you raised some complaints as to why you didn't sign. There's still some lingering stuff about how you're not particularly happy. At this point, it's just, you didn't sign off with the requisite enthusiasm and timeliness that it makes sense to go forward with this. It's just, the fit's just not quite right.
Well, I think that, I guess that could be one inference of the evidence, but it's certainly not the only inference of the evidence because, that you could draw from the evidence, because there's other evidence in the record that I just said that she was enthusiastically trying to stay in the Office of Ocean and Polar Affairs as early as June. Like she tried to submit the paperwork at a June 3rd meeting. She, again, as I said, emailed on June 7th, trying to submit her paperwork to stay in the Office of Ocean and Polar Affairs. She again followed up on she called every week. And then on July 7th, again, explained that she just wanted to make this one clerical change from from mentor to supervisor. And then again, on July 12th, the State Department responded, that's fine, you know, no problem, we can go ahead. So I do think that if the State Department this whole time was actually like getting more and more frustrated with her about the fact that she was taking too long to respond or any other of those kinds of concerns, that some of it you would expect to see in their email on July 12th, but there's nothing like that. It just says, please confirm you are on board with this approach. So certainly I suppose a jury could draw that inference, but it's not the only inference that you can draw from the evidence.
What did she do after July 12th?
She responded on July 20th that sounds great, but by then they'd already sent her the email on July 19th rescinding her fellowship. So they didn't follow up. They didn't say, like, first of all, when she sent the email on July 12th, they didn't say respond within a week or give her any deadline by which to respond to confirming that she was on board with that approach. So she responded approximately a week later saying that sounds great. But by then they'd already rescinded her fellowship without alerting her that she had to
The
respond.
July 19 communication from state, you referred to it as an email. Is it clear that it was not a letter? There are references to it as a letter, I believe.
Yeah, so it's a letter that I think was sent by email. But yeah, it's a
The reason I
J.
ask is because it seems odd that the next day, apparently, she hadn't seen it. She says, that sounds great, you know.
Well, she,
Not have seen whatever it was saying.
well, she
Better.
says, yeah, but she says that, like, that sounds great, but that AAA, sorry. Basically, she says like, that sounds great, but AAAS maybe has changed its mind or something. I need to find.
Where is that, July 20th?
Sorry.
Oh, I see. It's on J 229.
Oh, yes.
This sounds great, but it sounds like AAAS has made their own decision about wording. That's about wording.
So it betrays no awareness of having been told that the job was off.
Yes. I think at that point, she hadn't yet received the
Yeah.
email.
What email address was it sent to? Well, I guess, was it sent to the same email address she used to send the July 20th email?
Not sure.
I don't know, do we even have indication that it was emailed, that the letter was emailed? Maybe there is.
I'm just. Sorry. Looking.
Everything's email nowadays, but I just don't know.
Yeah.
If it's not immediately available, that's okay. Yeah, just one final, just to put a final bow on this. When she says in the July 20th emails, it sounds like AAAS has made their own decision about the wording. What's that a reference to? Do you know?
I don't think the record really reflects that, but it suggests that she may have received the email.
I thought
I
it
mean,
was
the
about
letter.
using point of contact instead of, or so here instead of men's.
Well, I think it's not clear because at that point, she wanted Sawyer to be referred to as her point of contact / supervisor. And Dana had responded that that was acceptable. And so then for her to say that the wording isn't.
It would be strange if she was referring to the July 19th letter by saying it sounds like AAAS has made their own decision about the wording, because the July 19th letter doesn't have anything to do with wording. It just has to do with non-renewal.
Yeah.
So it's just odd if AAAS has made their own decision about the wording. It's meant to be a reference to the letter that was sent the previous day, which she may or may not have received by the time she said that. So it's great. Just for to know. Okay.
Yes, I'm not sure what the best inference to that is.
Oh.
I'm trying to think through what a reasonable jury should be expected to do with this chronology. Let's say that a reasonable jury would think that Dr. Qashu was faultless from, I think, June 6th, somewhere around there, where the offer for a renewal was first made, through July 12th, when this email says, basically, we've decided to give you what you want. Please confirm that you are on board with this approach, and I will let AAAS know. And then she goes a week without confirming that she is on board. I mean, if you were offered a job or your current job, hypothetically, a clerkship, even if the judge was very forgiving, if you were offered the job, having been given the conditions you wanted, and he or she said, let me know, and you took a week, you ghosted him for a week, it seems like the fireable offense or a reason not to continue to offer the job to you, right?
Well, I think that here, I mean, in the context of this email, Jenya Dana herself had taken nearly a week, 5 days to respond to Dr. Qashu's email. She took until July 12th to a July 7th email. And so in the context of that type of communication, I'm not sure that a reasonable jury would necessarily conclude that Dr. Qashu's waiting of about a week was unreasonable, especially because Dana did not give her a specific deadline by which to reply.
Thank you.
Thank you, counsel. Thank you to both counsel. We'll take this case under submission. Can we take a short recess, Ann?
This honorable court is again in session. Be seated, please. Case number 24-5234. Milton S. Hershey Medical Center et al., appellants versus Robert F. Kennedy Jr. in his official capacity as Secretary of Health and Human Services. Mr. Connolly for the appellants, Ms. Shams for the appellate.
Mr. Connolly, please proceed when you're ready.
May it please the court, Ron Connolly for the appellant hospitals. I request to reserve 2 minutes for rebuttal. This is a straightforward case. The secretary violated the plain text of the Medicare statute, admitted that violation publicly in the Federal Register, and then promulgated a compliant rule retroactive to 2001. These actions compel him to recalculate hospitals' Medicare payments back to 2001. The reopening regulation states that the secretary that a decision must be reopened if the secretary states the decision is inconsistent with the applicable law. In the Federal Register, the secretary so stated that the prior interpretation was inconsistent with the statutory requirements. This is a plain and straightforward application of the reopening regulation.
Can I ask you, if we don't, you'll resist this, but I'm just asking you to do it. If we don't look at the example and we only look at the text beforehand, do you have an argument?
Well, yes, the text beforehand requires an explicit direction. And I think even without the example, the statement in the Federal Register constitutes an explicit direction.
Well, no, but it does by providing explicit direction to reopen.
Explicit direction to reopen.
Is there any way to read the rule as giving an explicit direction to reopen something that was closed?
Without the example. I think that, without the example, I think you can reasonably infer that the statements in the Federal Register clearly stating that the prior interpretation was contrary to the law, coupled with the Monmouth and In re Medicare reimbursement decisions, which concerned a prior regulation, but nonetheless, that reasoning applies here, that when there's an explicit acknowledgement, that constitutes a direction to reopen.
I don't understand. It's hard for me to see how it can be an explicit direction to reopen when the explicit direction actually is not to reopen. Because that's what it seems like. Again, apart from the example, you've got the example. I'm not denying you the example, but I'm just trying to understand contextually how to read the example. And if we take out the example, what the regulation says is CMS may direct to reopen by providing explicit direction to reopen. And the one thing it seems like the Federal Register notice says is don't reopen. If it's already open, obviously fix it. But if it's closed, don't reopen that.
Yeah, I think that, I know you want to put the example to the side, but the example is a clear example of when there is a direction to reopen. And our case fits squarely within that example, which is virtually identical to the regulation unaffected when Monmouth and In re Medicare reimbursement.
I guess where I'm going with this is even putting aside that for mandamus purposes, you've got to be clearly right. And that's the only way to read it. The natural way to read an example, at least to try to read an example, is so that it can be reconciled with the thing of which it's supposed to be an example. And the thing of which this is supposed to be an example says you will reopen when CMS directs you to reopen. And just, if you didn't have the example, it's very hard to see how the rule could be a direction to reopen when it actually directs the opposite. And then the question is, does the example go so far as to negate that all the way to the point that for mandamus purposes, it's absolutely clear that there was no alternative way to read it other than that you actually have to reopen, even though you said not to.
The example is clear. The first part of the regulation says CMS may direct with an explicit direction. And then but the example says a decision must be reopened. So the example uses mandatory language. So here is an example of when CMS has exercised its discretion to order a reopening. When CMS says that the prior determination was inconsistent with the applicable law. That example also discusses, as those were understood at the time. And here, the retroactive nature of the revised GME regulation is clear because CMS issued a retroactive rule, which is primary retroactivity. It changes the past legal consequences of past actions. The rule that was in effect at the time is now the rule that was promulgated following the Hershey decision.
But I thought it was, and as CMS understood those legal provisions at the time, I thought at the time, actually, CMS didn't have that understanding. That's the whole reason that you've got the subsequent questions about.
So retroactivity is a powerful tool that CMS used here. And the meaning of retroactivity is that it changes the past legal consequences of past actions. That's what CMS did. CMS changed the rules that were in effect at the time. If you look at the revised GME regulation, it doesn't mention open cost reports, closed cost reports. It just discusses cost reports on or after 2001, all cost reports. So that is the rule that was in effect at the time. This is the effect of retroactivity. It's a powerful tool. The Supreme Court has said that retroactivity is not favored. Congress came in after that and gave the Secretary very limited authority to issue retroactive rules, understanding that it should be rare. And the Secretary did that and found both that retroactivity was necessary to comply with statutory requirements and that retroactivity was in the public interest. So the Secretary has changed the rules that were in effect at the time of these determinations. Under the reopening rule, that compels him to revise the cost reports because there's been an explicit notice and explicit direction.
And am I right that in order for you to prevail on mandamus, then you have to show that it's absolutely clear, not just that the example seems to at least be in some tension with the thing of which it's an example, and that CMS understood those legal provisions at the time, even though you'd have to conclude that they retroactively were deemed to have understood that at the time, but then it also have to get past the prohibition against a reopening where there's a change of legal interpretation made in response to a judicial precedent. You also have to be able to negate that.
So a couple of points about the prohibited reopenings, Your Honor. First, our position is that CMS did in fact issue a reopening. So we're certainly not arguing that that's prohibited. The Secretary is in the unusual position.
You wouldn't want to argue that's prohibited.
The Secretary is in the unusual position of arguing that his own actions are prohibited. That's certainly not our
I think the Secretary's position is that they wouldn't have done that because it would have been prohibited. So the best way to read it is that they didn't mean to do something that would be prohibited.
That may be their position. Our position is that they did in fact issue the reopening by issuing the explicit notice. And again, the retroactive nature of the rule means that there is no change in interpretation rendering it a prohibited reopening. It's important to keep in mind the chronology of the reopening rule. In 1988, the Supreme Court said in Bowen v. Georgetown that there is no right to create retroactive rules into the Medicare program. And then Monmouth comes around. 2002, in response to Monmouth, the Secretary revises the reopening regulation. Then in 2003, Congress gives the authority to the Secretary to issue retroactive rules. So when the Secretary issued the 2002 reopening rule, there was no authority to issue retroactive regulations. So that could not have been contemplated as part of this rule. So our position is that within the plain language of the rule that the Secretary promulgated in 2002, the reopening rule, the retroactive nature of the rule that he promulgated later means that that the Secretary has issued a reopening and it's not a prohibited reopening.
I'm sure my colleagues don't have.
You have a pretty capacious understanding of, was it fault or fraud and similar fault?
It's yeah, fraud and similar fault. We
Would that same understanding apply to claims that hospitals committed fraud or similar fault?
well, yes. To be clear, Judge Walker, we are not contending that the secretary committed fraud. We contend we have no reason to believe that he knew that his rule was unlawful. We contend that he committed similar fault because he reasonably should have known. If anyone in this country should understand what the Medicare statute requires, it's the Secretary of Health and Human Services, who is appointed and confirmed by the Senate, charged with administering that statute. There is a definition of similar fault that does not include intent. The very text of the similar fault regulation is new or reasonably should have known. So we contend that he reasonably should have known that the state secretary that.
I appreciate that, and I was following that argument in the brief, and I think you may have already answered this to my first question. Just want to double. I mean, this line that stood out to me in your reply was the Medicare standard contains no knowledge requirement. You're talking about similar fault. The Medicare standard contains no knowledge requirement. Is that something that you want to live with when you're the one accused of similar fault?
That's what the regulation says. It says no knowledge of wrongdoing. It's reasonably should have known. That's what the text says.
Is that a yes?
That's a yes.
Could you run your answer to the prohibition again for me? Run that by again, please.
The prohibited reopening?
Yeah.
Yes. So a couple of things. As I mentioned before, we're not arguing that it's a prohibited reopening. We're arguing that the secretary did in fact issue a reopening.
Right.
That's their argument, that it's a prohibited
And what is
reopening.
your answer to it?
I'm sorry?
And your answer to it?
And our answer to it is that the retroactive rule means that this is not a change in interpretation.
Okay.
It's primary retroactivity, changes past legal consequences of past actions.
Okay, thank you, counsel.
Thank
A little
you.
time for rebuttal. Shams?
May it please the court, Sophia Shams on behalf of the government. In 2022, CMS issued a revised regulation that revised its calculation for certain Medicare reimbursement determinations. And pursuant to its authority under section 405.1885C, it declined to apply this new regulation to closed payment determinations. Plaintiffs now ask this court to require CMS to reopen their closed payment determinations. But section 405.1885C does not impose any such duty, and it in fact expressly prohibits the exact reopening that plaintiffs seek here today. For this reason, we ask that the court affirm the district court's denial of mandamus.
Can I ask you kind of the exact opposite question that I tried to ask of the other side, which is, suppose that all we had was the example in the regulation and we didn't have the part that came before it.
Mhm.
The better reading of the example that explicit notice was given?
Sure, I think even if we just had the example, this particular example and not the prior regulations example, but this particular example, we still would argue the same thing that we're arguing with today, which is that the regulation that was revised that CMS issued did not constitute the kind of explicit notice that the example discusses. And that's particularly because of that secondary part of the example that Your Honor pointed out, which is inconsistent with the applicable law or regulations as CMS understood those legal provisions at the time that the determination or decision was rendered by the contractor. That secondary language at the time CMS understood those legal provisions was later added post-Monmouth, and it's precisely to avoid the kind of decision that was rendered in Monmouth in which the court had determined that CMS didn't have this kind of discretion when it comes to reopening or directing reopening of a particular determination.
So before we get to that part of the example, if we're just talking about the very first part, which is a contractor determination must be reopened and revised if CMS provides explicit notice to the contractor that the contractor determination or contractor hearing decision is inconsistent with the applicable regulations. That part of it seems like it applies to this situation, given the.
I think if all we had was that, we didn't have the first part of CMS directed reopenings with May Direct, and we did not have the second part of the provision, which is prohibited reopenings, that would be a situation that's a little bit closer to Monmouth, and it would be a more difficult argument for us to be making today. I do take the point of perhaps that part of the example on its own indicates a different meaning, but that's precisely why CMS revised the regulation, because that was the prior regulation. The prior regulation just had shall be reopened if there's a determination that's contrary to the applicable law. And this court had interpreted that regulation in a way that CMS did not intend for it to interpret. And that's why CMS revised its regulation in 2002, stated that it was revising it in direct consequence of Monmouth, and then stated that it was revising it to express its longstanding interpretation that the secretary has discretion as to whether it's going to direct reopening. So I think looking at the example, part of the example clause in a vacuum would be a mistake that disregards what CMS did in this case and in revising its regulation, which is why we asked the court to look at the first part of the regulation, subsection 1, which states that CMS may direct. That provides an explicit indication of discretion on part of CMS that it did not invoke here. And then we also asked that the court look to the second part of the example clause, which talks about as CMS understood those regulations at the time the decision was rendered. And then even if if the court still disagrees, we ask the court look to the second subsection of section 402.1885C, which expressly prohibits reopening when it's based on a change of legal interpretation or policy by CMS in a regulation, whether that be made in response to judicial precedent or otherwise. And that's exactly what we have in this case. What we have is a case where the district court issued a decision that CMS's prior regulation for calculating FTE calculations was improper and against the statutory requirement. And so CMS revised the regulation and it applied it retroactively to 2001. And it stated that it was prohibited from reopening prior determinations on that basis. So I think the text of the regulation is fairly clear. And I think I'll just also briefly address Judge Walker's argument. I think it's true that the plaintiff's understanding of fault or similar fraud is a pretty capacious understanding and that we should read that phrase together. Our argument in brief is that similar fault requires some similar knowledge requirement as fault does. And that even if the court doesn't agree with that understanding, it's still a discretionary act by the secretary. The secretary may reopen if there's a finding of fraud or similar fault. So it wouldn't warrant mandamus here, which is pretty extraordinary relief.
Does the similar fault question just go to the time limit, the 3-year time limit, if I'm remembering, or does it go to everything?
I think the similar fault question, I think plaintiffs invoke the similar fault question to argue that they should get reopening all the way back to 2001. And so I think you would only get to that question as the district court didn't get to that question because it answered that there was no entitlement to reopening in this case under 405.1885C. I don't think this court needs to answer the similar fault question if it determines that section 405.1885C doesn't require reopening.
You give a very clear answer to a very unclear question, so thank you.
Of course. Well, if there are no other questions, then I'll be happy to sit back down and we ask that you affirm the district court's denial of mandamus. Thank you.
Mr. Connolly, we'll give you the 2 minutes you asked for rebuttal.
Thank you very much. A few points, Your Honor. The issue of explicit notice was brought up, and I just want to point out that the district court agreed that, quote, CMS gave explicit notice that prior determinations were based on a weighting formula inconsistent with the statute. Now, the district court disagreed that that was an explicit direction, but I just want to point out that one part of the district court's opinion that we agree with is that there was explicit notice here. Monmouth was also mentioned, Ms. Shams discussed how the secretary revised the reopening regulation in response to Monmouth. I want to point out that this is not Monmouth. The reasoning of that opinion applies, but this is a different case in a couple of respects. One, in Monmouth, the secretary did not admit that the prior interpretation was contrary to the statute, and the secretary did not issue a retroactive rule in Monmouth. So the secretary may have been trying to prevent a repeat of Monmouth, and when promulgating the 2000 rule, the secretary may have succeeded. This is not Monmouth for the reasons I mentioned. Retroactive rule and no admission by the secretary that the prior determination was contrary to the statute. Similar fault was just discussed. I just want to point out that the similar fault rule does not engraft an additional layer of discretion. Similar fault provision is a timeline that applies after the secretary has given an explicit direction. So the secretary has authority to give an explicit direction. We contend the secretary did that. If you agree with that, then you look at the timelines, and the similar fault provision does not engraft another layer of discretion on top of that after the explicit direction has been issued.
The rule has a part about reopening and a part about when not to reopen. And even if I could get pretty on board with your interpretation of the reopen section, why should we privilege the reopen section over the don't reopen section?
I'm sorry, Your Honor, are you talking about the prohibited reopening when you refer to the don't reopen?
Yes, that's the.
So you should, they're both important, clearly. But again, our contention is that the secretary did reopen. And again, our position is that the retroactive rule means that this is not a change in legal interpretation. The secretary changed the legal interpretation in effect in 2001 by altering the rule, changing past legal consequences of past actions.
Thank you, counsel. Thank you to both counsel. I'll
Gotcha.
take this case under submission.
Case number 24-1298, World Shipping Council petitioner versus Federal Maritime Commission and United States of America. Mr. McGovern for the petitioner, Mr. Summers for the respondents.
Good morning, counsel. Mr. McGovern, please proceed when you're ready.
Good morning, Your Honor. May it please the court, Robert McGovern for petitioner, World Shipping Council. This case addresses whether the Federal Maritime Commission adopted a rule that exceeds its statutory authority under the U.S. Shipping Act and is arbitrary and capricious under the APA. To address COVID-19 supply chain disruptions, including when shippers were competing for very limited vessel space during a time of unprecedented demand, Congress amended the Shipping Act and directed the FMC to adopt a rule that defines the term unreasonable in the context of negotiating and providing vessel space. That rule that it adopted violates the Shipping Act and the APA in three key respects. First, the rule impermissibly allows the FMC to regulate ocean carrier prices, notwithstanding Congress's express repeal of that rate-making authority over 40 years ago. Second, the rule directly interferes with the business of ocean carriers by requiring them to create, file, and then have their actions judged against prospective export policies. And third, the rule consciously jettisons legitimate business reasons as an explicit factor with no meaningful or logical explanation, reversing decade-long precedent that the FMC itself relied on in its own proposed rule. As to the rate-making factor, the rule allows the Commission to consider, quote, the quoting of rates that are so above market rates that they cannot be considered a real offer or an attempt at engaging in good faith negotiations. But Congress explicitly repealed the Commission's statutory rate-making authority in 1984, and it did so for a very specific reason. Quoting legislative history, Congress determined, quote, excessive government involvement has unnecessarily interfered in many aspects of shipping activity where commercial parties more appropriately should govern their own conduct. This is on pages 7 and 8 of our opening brief. And importantly, this statutory regime remains even after OSHA 22 was passed. Now, I expect that my colleague will argue that the rule only allows the Commission to evaluate and not to set rates. But whatever terminology the FMC wants to use, consider, benchmark, evaluate, there's no scenario under which an agency that does not have statutory rate-making authority can then turn around and tell regulated entities that their rates are too high. That rate-making factor in the rule also fails under the APA because the commission never explained what it means for a rate to be too high. It never explained what methodology it would determine what a reasonable market rate might be in comparison. And it never explained what amount of deviation between the two would, in the commission's view, be considered unreasonable. Section 4104 of the Shipping Act also does not allow the commission to require carriers to create and file prospective export policies. And as always, on questions of
May I
statutory.
ask you about the business decisions argument?
Of course.
As you know, FMC indicated in the rule, quote, information on business decisions relevant to establishing a reasonable refusal to deal would still be relevant. And I would interpret the APA's arbitrary and capricious standard to require the agency to consider relevant factors when it takes agency action. So putting kind of those two things together, why should I be worried that the FMC will not consider business decisions as a factor when the business decisions are relevant?
Thank you, Your Honor. So we have to start from where the FMC started in the proposed rule. And they had business factors explicitly in there.
I mean, why?
Because they said, we have business factors in here because it is a recognition of our longstanding policy that this is a factor that we consider when addressing reasonableness under the statute. The FMC is not starting from a blank slate here. 41104, A3, and A10 were already in the statute when OSER 22 passed.
They don't have to persuade us that the final rule is better than the proposed rule. They just have to persuade us that the final rule is reasonable and reasonably explained.
And I think, Your Honor, to answer your question, why should you be concerned? The FMC has made a choice here. The FMC has said that these factors were in the proposed rule, but then we removed them. And we removed them because we had a concern that they had the potential to overwhelm other factors. That's at JA 51. That's not an explanation of departing from your past precedent. What that is saying that a factor is apparently so significant that it has the potential to overwhelm factors, but not significant enough to be listed alongside those in the rule.
I'm going to ask them about that. I do think it's a little wild that that was the best they could do in explaining what they did. But I'm asking you in part because I think it goes a little bit to the merits, but a little bit to standing. If I have every reason to believe that in spite of we're not going to include business decisions in the rule because they're too important to include, or some version of that. Regardless of that, if I have every reason to believe that information on business decisions that are relevant will be considered, then I'm not sure how a party that says we want business decisions that are relevant to be considered is injured.
Your Honor, I would answer your question this way. One, the FMC has already signaled in both its rulemaking and its brief that how it wants fact finders to adjudicate these cases. It's making a conscious policy decision now to deprioritize these. They've listed some factors, they've taken business factors and said, we may consider them down the road. There's also a slip of the tongue that the FMC makes in both the rule and its brief when it says that it removed business factors from being something that they must consider to being something that they may consider under the regulatory catch-all that you're referring to. Well, our understanding is none of these rules all of them are a suite of non-exclusive factors.
But even if they said we're changing it to may, if the APA requires them to consider business decisions when the business decisions are relevant, it seems like regardless of whether they said may or must, the APA imposes a must.
And Judge Walker, I would say that the FMC has made promises like this before. In a case before this court, Evergreen versus the FMC, involving an FMC interpretive rule, the FMC said in that rule, we'll consider one factor and we may consider a number of other factors. And then the first time that the FMC had to evaluate that, they considered only the one and ignored all the others.
And then what did you do?
We challenged it in court. And what we're hoping to do now is
I don't remember. Did you win?
We did, Your Honor.
So why not? Why isn't that, from a standing perspective, injury that's either now or imminent, why wouldn't we require you to do what worked for you last time.
Because the lack of explanation on the business factors, we don't consider, Your Honor, our argument, World Shipping Council's argument, is that just saying that we may consider it as part of a regulatory catch-all is not sufficient under the APA to explain why the FMC is departing from past precedent. We both don't believe that we should have to wait until some future adjudication. We believe that violation under the APA exists now, and that's why we're challenging it now.
Mr. McGovern, in your reply brief, you deal with the state of California case that the commission produced. And your response is that to the commission is that that Congress expressly removed the relevant authority in 1984, and continuing on that a removal of this authority, as well as Congress's removal of the commission's general rate-making authority, suggests that California would be decided differently under the current version of the shipping. So looking at the then prevalent, then prevailing and now incumbent versions, I see that when California was decided, 1944, I think, every such carrier shall establish, observe, and enforce just and reasonable regulations and practices. Whenever the board finds that such regulation or practice is unjust or unreasonable, it may determine, prescribe, and order enforced a just and reasonable regulation or practice, which in 1944 was prescribing rate change. Current version, a common carrier may not fail to establish, same as must establish, observe and enforce just and reasonable regulations and practices, etc. Commission may prescribe regulations to carry out its duties and powers. What is lacking in the current version that was present before that could explain, that could put California to one side?
So the state of California, you're right, Your Honor, a 1944 Supreme Court case cited by the commission to support its inclusion of the rate-making factor. That case was decided under the 1916 Act.
I just read the provisions from 16 and from the current.
So the provision under the 1916 Act, Your Honor, the difference is that the FMC in that case, pardon me, the rate-making authority in that case, they
didn't have authority over the carrier in question, well, or the port in question, because it was a state entity. Right, so they didn't have rate-making authority over that entity. I think it was the city of Oakland, but nonetheless, because there was an unjust, unreasonable practice, so found they were able to prescribe a rate as the cure.
And Your Honor is right, to determine, prescribe, and order enforced just and reasonable practice, but they were utilizing their authority in the 1916 Act in that case, their rate-making authority that they don't have now. And that is why we believe that the removal of that authority in 1980.
They're using their rate-making authority when they didn't have rate-making jurisdiction over that entity.
Well, Your Honor, the court's reasoning in the state of California case was that the commission could require certain compensatory charges due to Congress's, and this is quoting from the case, Congress's unlimited grant of the power to stop those practices. So the practices in question in the California case related to compensatory charges, and the unlimited grant of power that the Supreme Court referred to was the authority that the commission had prior to 1984 relating to its power to regulate charges.
The withholding of rate-making, this is from the case, the withholding of rate-making power for services other than water carriage does not qualify the unlimited grants of the commission the power to stop effectively all unjust and unreasonable practices in regard to handling of freight. Finding a wrong, which it is duty-bound to remedy, the commission may, within the general framework of the act, fashion the tools for so doing. Seems to be pretty clear that they're just saying they don't have rate-making authority, they've got an unjust practice, they have to deal with it, and they can do it by prescribing a rate.
Your Honor, I would answer your question this way, which is only then the situation that we have before us is very different than the state of California case. The situation that we have before us is not just determining, prescribing, and ordering as it relates to the rate-making factor, What the FMC has done here is that we're going to consider whether or not a rate is so high above market rates to be considered unreasonable. We say there are two problems with that. One, from a statutory perspective, how does this play out? So somebody challenges an ocean carrier rate and it goes to the commission and the commission says, that's too high. It's too high above a market rate. One, we don't know what market rate they're using to compare it to, but the carrier's only then remedy on this one is to reduce its rate because the commission just told it that it was too high. And how does that play out? That plays out by, well, what if the shipper then continues to say, no, the carrier's rate is still too high and goes back to the commission and says, still too high. The commission then under this rule can say your charge is still unreasonable because your rate is too high. That process would go until ultimately the carrier charges something that's consistent with whatever rate the commission determines to be reasonable. If that's not rate setting, then it's hard to see what is.
Well, no, the way it plays out, I take that scenario, I think it's an accurate portrayal of what to expect. I'm just not sure why it's different in the end, because it is in the end prescribing the rate. Right? Let's accept that it is.
And Your Honor, it is interesting that one, the FMC has not pointed to a single statutory provision that allows for this type of rate making authority because it can't.
Here, as you said, in California, the result was to require, what was it, a compensatory rate charge, to impose a charge. The problem was their charges were too low.
That's right.
The demurrage charges. So they were distorting the market for attracting traffic to Oakland. And so it says, they said the only way to correct the preferential and unreasonable results of non-compensatory charges was to require compensatory charges, to prescribe a rate, in other words. Right? And you're saying, well, effectively, that's what they're doing here by indirection. And I think if you're correct, it's still within what happened there.
That's right, Your Honor. And I would say it's interesting that the only case that the FMC cites to support its rate-making factor is a 1944 case when the FMC had rate-making authority. They don't have any other cases to cite it, and this is rate-making. And what courts have held is that agencies cannot do indirectly what they're going to do.
Rate-making authority over Oakland. So that's your problem.
Can I ask a question coming at it a little differently, the same set of issues though? The statute prohibits unreasonably refusing to deal or negotiate. So if a rate that's proposed is so stratospheric that it's indicative of a refusal to reasonably deal or negotiate, is that something that the commission can take into account?
Your Honor's question is a situation that the FMC discussed in their brief. They used the words, well, what if a rate is so absurdly high that it can't possibly be considered a refusal, an actual good faith negotiation? The answer is one, we don't know what the FMC means by absurdly high. Nobody does.
Do you disagree that there's no such?
But nevertheless, that's right. If Congress wanted the FMC to have the authority to regulate rates, it would have expressly given them that authority.
I'm trying to get my answer. So suppose they say $1 billion. Okay, do you think that's something that the commission just can't consider?
Not as a factor for reasonableness, Your Honor. That's right. That's a rate-making factor. And I would add to that there's Congress has made this decision. And the reason is that's ignoring market realities to say that there's nothing that can be done. If an ocean.
Okay, so how about this? They say, I'm not going to negotiate with you. That clearly is a violation.
It is, and that's expressed in the FMC's.
Okay, and then they say, oh, darn it, I have to negotiate. Okay, $1 billion. So your answer is?
The FMC doesn't have the authority to use rate making as a factor of reasonableness. But if the carrier offers $1 million, there's only two ways that a carrier can make that offer, either through a service contract or through a tariff. If it makes it through a service contract, the shipper is just going to turn around and go in a very competitive industry to any other carrier that's going to give them a much different rate, obviously. If that $1 billion is in the tariff, well, an ocean carrier has now just effectively turned away its entire customer base. It's precisely those market realities that cause Congress to say that the market polices itself, and there isn't a role for the FMC in the space. So, Your Honor, the answer to your question is no, that's not a factor that the commission can consider as reasonableness, even under the hypothetical that you've used.
So they consider refusal to deal in that hypothetical situation based on something other than the rate that's proposed.
That's right.
That's the way you would look at that?
Yes.
And what would they look at if the only thing that's on the table is a rate of $1 billion?
I understand your Honor's question. And I guess, first of all of this is done on a case-by-case basis, right? And the commission.
That is the case.
If that's the only case, then WSC's position is that is a rate factor that the commission simply doesn't have the authority in the Shipping Act to utilize.
That's not a refusal to deal then.
Not under the commission's authority under the act.
Does it have the exact same effect as an express refusal to deal?
So in practice, I understand the question, but it comes down to whether or not the FMC has this authority to consider it as a reasonableness factor or not. It comes back to the act itself. And if the court accepts WSC's argument that the FMC does not have the authority to consider rates as a factor in a reasonableness analysis, because Congress not only did not give them that authority in the Shipping Act, but it took that authority away, then that's not something the FMC can use as a factor under reasonableness.
Company A says, I won't deal. Company B says, I'll deal, but the cost is $1 billion. There is no practical difference in the effect of those two companies' choices, correct?
Correct. Practically, that's true. And under the market realities, you've then got companies C, D, all the way down to M, in which case there are competitive options for these shippers. And this is
That
not
seems like it would apply also in the situation A, where the company says, I won't deal. It seems like your answer will be, well, it's no big deal because you can just go find company C through M.
the commission's rule says that a categorical refusal to deal with no justification is considered unreasonable, not something that WSC disputes.
Just to play it out one more time. So to take Judge Walker's hypo and just keep it with company A, the company A refuses to deal. You would say, okay, they can be justly held to account for refusing to deal. And then company A says, oh, okay, I guess I can't refuse to deal, so $1 billion. And then you would say, company A loses the first time, but wins the second time.
Your Honor, that's right. And that's the commission's point of saying, what if somebody does an absurdly market rate? And I would submit that Congress has already made that determination that in the first instance, that's something the FMC can find unreasonable under its authorities in the act. And the second, it isn't.
I think I know your answer to the next question. I don't want to totally prolong it, but the Chief Judge's question was about $1 billion. Your answer would be the same if it was $1 trillion.
Yes, Your Honor.
And your answer would be the same if it was $1 trillion in pennies.
Yes, Your Honor.
Thank you, counsel. We'll give you a little time for rebuttal.
Thank you.
Mr. Summers.
Good morning, and may it please the court, Harry Summers for the Federal Maritime Commission. This is not an example of rate making. This is not a freestanding complaint to the agency saying, hey, this rate is too high. As the questions that more than one of your honors were asking show, this is in the context of an administrative adjudication about whether there was an unlawful refusal to deal. That's a retroactive determination about whether one particular fact pattern, had an example of a rate that was so high it did not indicate a good faith negotiating posture in the context, and it only applies in the context before a deal has been made because it's only.
So one question I had about that is, I thought the way the commission framed this is that a rate might be unreasonable. Not that a really high rate would be indicative of an unreasonable refusal to deal, which that I can at least understand it for the reasons that were elucidated earlier. But is the commission's view that the rate actually itself can be unreasonable, or that a high rate can be indicative of an unreasonable refusal to deal?
This only arises in the context of enforcing the refusal to deal statute. Congress asked us to further define that statute. This is not a freestanding requirement about rates. This is one permissive factor that can be considered along with other factors, as has been discussed, in evaluating in an administrative adjudication resulting from a private party complaint or the Commission's Enforcement Division beginning an investigation into whether there was an unreasonable refusal to deal. One factor the agency may consider is whether the rate quoted was so high that it doesn't reflect good faith negotiation. And I think in the
So
examples—
the commission can't say the rate that you proposed, I have authority to determine whether you're unreasonably refusing to deal. The rate that you propose is unreasonable. That you think can't be done. It would have to be the rate you proposed, potentially coupled with some other things, but let's just leave other things out. The rate that you proposed indicates an unreasonable refusal to deal.
I think that the commission is charged under the APA, as Judge Walker was saying, with a full evaluation and consistent with Judge Ginsburg's decision in Evergreen, a full evaluation of all the factors in the statute and in its regulation implementing the statute. In this case, there are a number of factors and examples the commission should consider. Some may be more relevant in a particular case than others. So in the case where there was a rate that was widely at variance with the market, that would certainly likely be an important factor, but not necessarily the only factor. So it's unlikely the agency would say, case closed, we're not going to consider any of the relevant factors. It would consider others that were relevant, consistent with the APA. So that's, if that answers your question.
The council tells us rates in this area are volatile and change from day to day, and there can be a great deal of dispersion among them. So what is the market rate?
I think the market rate would be determined, much as it may be in litigation generally. The parties would no doubt argue about what the market rate for the particular routes, the shipping routes that were at issue in this retroactive determination, what was the market rate at that time? And there's a number of resources that parties can consult to determine shipping rates. There's online resources and platforms that regularly publish detailed analyses of what the market rates are for particular routes. The commission itself has experts who evaluate these rates, economists. And so I think there's a number of resources, just as in any litigation, parties
So you can
could.
get pretty deeply into the weeds in terms of the rate examination. Is it fair to say that unreasonably refuse to deal or negotiate is essentially equivalent to refusal to bargain?
I think that's
bargain being pretty much synonymous.
I think that's basically right, Your Honor. I think
So there are probably thousands of cases under the Labor Act in which the Labor Board has brought an 8A5 charge or an 8B5 charge, claiming unreasonable, failure to bargain in good faith. And I haven't read them all, so I can't tell you, but I have read hundreds of them because I've taught the subject for some years and I've been on the court for 38 years. And I've never seen a bargaining in good faith charge that was based on an employer offering too low a number for some benefit or wage, or a union demanding something too far, way above the market. It's always about the process, bargaining in good faith. I mean, so for instance, General Electric under Bulwerism could not say, we will make a firm, fair, final offer. Firm, fair, first and final offer. That's not bargaining, okay? Doesn't matter what the offer is. So I'm not sure why you have to get into rates at all in order to determine whether someone is reasonably refusing to negotiate, or unreasonably refusing to negotiate.
Your Honor, I think it relates to the potential for that term to provide a method of circumvention of the statute. I think for the reasons that were discussed earlier, it would be very easy to effectively refuse to deal, perhaps because you felt you you could make much more money doing something else. This is something we saw that Congress saw during the pandemic, where a lot of US exports were left on the docks effectively because the carriers felt they could make a lot more money going back to overseas and bringing more products to the United States from elsewhere. Congress wanted the commission to try to strengthen this rule to avoid that.
Well, couldn't
One-
people negotiate in good faith and still come to the conclusion that they're not going to pick up this traffic? They've got better things to do?
It's possible, Your Honor, but it would be a very easy way to achieve the same result as simply refusing to negotiate at all if they could quote a rate that was absurdly high by any measure. So I think that's what the commission was trying to achieve. And it's important to remember that it's just one factor. So the commission can consider the other factors listed in the rule in an appropriate case. So it is a case-specific determination, not.
I think the example shows that in the labor area, that it's possible to enforce good faith bargaining or not to prevent unreasonable refusals to bargain without getting into rates at all.
In this case, I think the commission, based on
And it is a little bit dicey since rate-making authority was removed.
I understand that concern, but I think this is really so far removed from actually setting rates. And in fact, other parts of the statute, for example, sections 41, 104, A4, and A5, that Congress created do require that the commission evaluate, again, in the context of a retroactive determination about whether a practice was an unreasonably discriminatory practice or unfairly discriminatory. Rates and charges are specifically provided for as something that the agency should look at. So I think that Congress has, even though, as has been said, the commission can no longer actually set rates. It can evaluate rates in the context of adjudicative determinations to enforce other parts of the act that address
What is
things
the
like.
remedy? What's the remedy? If there's a complaint, a shipper's complaint, and the carrier is found to have failed to conduct themselves reasonably.
Your Honor, in the context of a private party complaint, the remedy is typically reparations, which are in the nature of damages. So it's,
Reparations, a sum of money.
yes, a sum of money.
And how would that money be measured if not against some hypothetical rate?
I think it would depend on the facts of the case, but yes, that is a likely measure of damages.
So ultimately, you have to determine a benchmark rate from which to compensate reparations.
In the context of a particular case about past conduct, yes, I think there would have to be some measure of how the claimant was injured. And so to the extent that they could have
So if
gained it.
you have a statute that says, is that a statutory provision, remedies reparations,
Yes,
lost profits or whatever?
Yes.
Okay. So if that's the provision, then I don't see how you can determine that without engaging in what you're talking about, rate evaluation.
yes, that's correct. But rate evaluation is very different from setting the rates.
Well,
That's not,
But calculating damages is very close to setting a rate.
well, it's evaluating one past rate on one particular fact scenario, not setting the rates. The market sets the rates. This is just a comparison point to be used in an administrative
What if you
adjudication.
have a case where there's just an outright refusal to deal? So take your archetypal violation where there's just flat refusal to deal. What would there be reparations or damages in that situation? And then the way you calculate it is what a reasonable rate would have been had there not been what everybody agrees is a violation, which is just an outright refusal to deal.
I think that could be the measure of damages. I think it would depend on the particular situation and what the claimant had to do or in order to move its products and perhaps in order to move its agricultural exports, or in the case that it could not move them, perhaps there would be damages related to being unable to move them. So, or perhaps unable to move them on time. So those damages would relate to the particular facts in the case. But yes, it could involve a determination of what was a reasonable market rate at that time. And it could be used by measuring data on some of the resources that I mentioned earlier. So that data is out there, so.
The provision requiring, allowing for reparations seems to me brings the case even closer into the California precedent.
Yes, I think that's probably
I
right.
don't see how it can be avoided. Okay, thank you.
The rule says, it talks about quoting rates that are so far above current market rates. And some of the questions we were asking your opposing counsel were fair or unfair, way above current market rates. Questions, I mean, 1,000,000% higher than current market rates. What do you mean by so far above current market rates? What's the floor on so far above?
I think, I don't think there is a precise definition, Your Honor. I think it would be very context dependent. Like so much that's in the statute that is phrased in terms like unreasonable, unfair, unjust. These are the kind of terms that Loper Bright mentioned that agencies may receive from Congress and are given a certain amount of discretion to define. Here, I think in a particular case, I believe the regulatory language is so far above market rates that they couldn't, they don't indicate a good faith negotiation or effort to negotiate and make a deal. I think if in a particular case, the agency were to define that in a way that was unreasonable, inconsistent with the APA, there'd be reason to object. But I don't think it's required to define in advance exactly what that would be. Certainly, we couldn't assign a number because there's so many potential variables with different shipping routes and over time and different economic conditions.
And if you
So-
did assign a number, that would look a heck of a lot like rate setting.
It would, even though still it's only in the context of a larger evaluation of refusal to deal and one of many potential factors. But
Your
yes.
approach, if I understand, is we don't want to rate set, so we're not going to set a number. Instead, we're going to leave you in the dark about what the number is.
I don't think it would be practical or perhaps even defensible to try to define a precise number because there are so many potentially relevant factors in a retroactive analysis of that type. So it would be very context dependent. And again, it's just one of many potential factors. So-
Has any shipper filing a complaint prevailed and gone to remedy since the amendment of the statute?
Your Honor, I'm not aware of one. I know there are some pending cases where the rule has been broadly cited, but I'm not aware that has
Could there be
happened.
cases before amendment of the statute in which reparations were awarded?
I believe so, Your Honor. I don't have an example in front of me.
Okay.
Yes.
We'll find them.
I guess my concern is it has to be that sometimes a rate can be quoted that's above market rate. Otherwise, market rates would never increase, right?
Yes.
And so if they're allowed to quote rates above market rate, they're not allowed to quote rates that are too far above market rate. You don't tell them what too far is. Seems like quite the bind they're in.
Your Honor, I think the language in the regulation is very strong in the sense that it's not superlative, but it's a very strong expression that the rate is very far removed from the market rates, so far above that it does not indicate a good faith negotiation. I think that's not like a small, inflation level increase. That's something more. And I think if the agency were to act unreasonably in evaluating that in a particular case, there would be certainly grounds to object and an opportunity on the part of the responding carrier to object to that. But in the abstract, and just based on the regulation by itself in the abstract, I think it's a reasonable expression of an important method to avoid circumvention of the statute.
But if you prevail here, and then if at a certain point a petition is filed saying, we quoted a rate and it really wasn't so far above current market rates, but it was used against us. I'm on the panel. I'm going to quote what you just said. And in deciding the case. I'm sure you think is fair.
Fair enough.
I suppose you could also have a concern on the commission's part that if you tried to identify some kind of parameter on what is so far above that it would pose an issue, that it could be that there's actually a good explanation for why something that's far above actually shouldn't pose an issue. And I assume the commission's open to being persuaded on that. And one reason why you might be reluctant, the commission might be reluctant to try to identify a number or a range could be that that number or range could turn out actually not to be prohibitive. And in fact, it turns out that you can be within the realm of good faith negotiation and still propose something that might at first appear to be outsized because of some contextual considerations that just are unpredictable at the moment.
Yes, Your Honor, I think that's right. I think in many cases, the kind of scenario you suggest would actually cause the market to change. And so such a rate that was for those reasons would also affect the rates being charged elsewhere, other carriers are quoting. But if for some reason that wasn't the case, there are the other permissive factors in the rule to be considered. And it may be that those factors would outweigh this one in the analysis. And in fact, there is the catch-all provision where the agency will consider any other relevant factors or elements that may bear on that decision. So the carrier could certainly, citing those provisions, make that argument, and the commission, I believe, would consider that carefully. So.
Can I ask you about the business decisions
Yeah.
regulation? Will business decisions be a less important part of the analysis than they were before this challenge regulation was promulgated?
Your Honor, I understand the question. I don't think that the commission indicated that they would be less important. I think that it elected, after consideration starting in the NPRM and through the SNPRM and in the final rule, not to include that as an explicit factor in its new rule. There had never been a rule like this before, so it wasn't like it was changing some previous rule. It didn't include that. It did point to the apparent potential for the factor to be given more weight than some of the commenters felt was appropriate. It elected not to specifically put it in the regulation. However, it made very, very clear in the preamble and the other rulemaking documents that that was a factor that was still potentially relevant, that the agency would consider going forward. It made mention of the past adjudications in which that had been a factor, which my friend cited in the brief. Those remain relevant. The history of this is that it was a statute that was explained in adjudications over the years, and all that material remains relevant here. The rule didn't prohibit consideration. In fact, those catch-all provisions that I just mentioned are what allows the business decisions to still be considered.
So that all sounds pretty fine. There were a couple lines in the brief, though, that seemed more aggressive. One of them is you say that the petitioners seem to be using business decisions as a kind of code for always seeking to charge the highest rate, as the commission recognizes. I understand that in terms of what the carriers give, there's going to be plenty of requirements and they're going to be expensive, and that's going to cut into profit margin maybe. But in terms of what the carriers get, right, the money they get for carrying, I don't understand why they wouldn't always seek to charge the highest rate.
I think the import of the language you're talking about isn't that they can't seek to make a profit. It's just that that's not the only consideration in making the kind of determination.
When should they not seek to charge the highest rate?
Well, I don't think I think if they sought $1 billion, then that would be an unlawful refusal to deal. So there are contexts where that.
Which is a scenario that you've already covered.
But that, I mean.
For your other regulation. I mean, I think what your argument is in defense of that regulation is it's not really going to the rate. It's using an exorbitantly high rate as a pretext for not dealing. I mean, I would think, especially if these companies are publicly owned, it would be perhaps even illegal in terms of their duty to their shareholders to not seek to charge the highest rate.
It's really part of a larger analysis. So it's not that they can't or shouldn't seek to charge a high rate. It's that if in evaluating why they refuse to deal or why they refuse to provide cargo space, a factor is what their position, shall we say, as to these business factors or business decisions. It's not an automatic basis to evade the statute, to cite that. So
That's not at all what petitioners are asking for, and that's not at all how the proposed rule would have read. The proposed rule would have just said business decisions are a factor that the commission considers.
And they are still a factor. So I feel like it's where Congress hasn't required that we state any particular
So
factor in the
you
rule.
said they are still a factor. I just want to pin that down. It would not be okay for the commission to decline to consider a relevant business decision, correct?
Yeah, I agree with that. A relevant business decision, yes. Yes,
Because it would be arbitrary not to.
correct. Yes.
If the objective is to determine whether they are negotiating in good faith, the question about the rate is, I think should be, whether that rate is indicative of a desire ever to reach agreement,
I believe that's right, Your Honor. Yes.
or not just that rate, but any rates, counteroffers, and so on.
Thank you, counsel.
Thank you.
Mr. McGovern, we'll give you 2 minutes for rebuttal.
Thank you, Your Honor. I want to address a few things that have been discussed today. First, on what I will refer to as the billion-dollar hypothetical. I mentioned that there are two ways for a carrier to price their ocean transportation services. One is through a service contract, one is through a public tariff. In the billion-dollar hypothetical we're talking about, ocean carrier A goes to a customer, a potential customer, and says, sure, I'll move your cargo, but only for $1 billion. We have to keep in mind, too, that customer, not just the competitive options that I've mentioned earlier today, but that customer also has the ability to move cargo under the ocean carrier's tariff. And the tariff will not say $1 billion. And the reason a tariff will not say $1 billion is because if it does, it's effectively turned off its entire customer base. So there are options here. And, you know, the reality is understanding the court's practical questions about it. But there is a way for the way that the market works for a shipper to get the service it's asking.
Well, you're saying that no one ever pays more than the tariff?
Usually the tariff is on the higher side, and usually through an individually negotiated confidential service contract, you come to a lower rate. That's usually the case.
You referred to the instability of the rates and market rates being all over the place. Well, now you're telling us below whatever the tariff rate happens to be. Is there a public source of information on that?
Tariffs are publicly filed.
No, of the fluctuation in rates. You said there was, I think you indicated there's a commercial service or something that publishes.
The commission mentioned that there are a number of public services that are available. Things like companies like Alpha Liner and Piers and Drury. There are people who do monitor the rates.
And are those all behind a paywall?
Many are behind a paywall.
Is there one that's not?
Among the ones that I've just mentioned, Your Honor, they're all behind a paywall. And on that point, on the market rates, you know, the rule, despite what we heard from my colleague today, the rule doesn't say anything about what a market rate would be or where it would be developed. It doesn't say anything about any of these public services or how the FMC would determine what would be too high. And it doesn't say anything about what deviation between an actual rate and a market rate would be. We just don't know. And at that point, that gives carriers have no ability then to run their businesses, and the FMC has discretion to just decide for itself without any clarity in the rule. The FMC in its brief in here today also.
On the business decisions, regulation, you heard the government just say that the commission must consider relevant business decisions. If that's how we read the regulation, do you have standing?
We still do have associational standing, Your Honor, to challenge all three of these, but that's not what the regulation says.
Well, but how are you injured by a regulation that is read to require the commission to consider relevant business decisions?
If the regulation were to be read that they must consider business
Relevant
decisions,
business.
that's in line with its past precedent, and therefore there's not an APA violation. The APA violation here is
You wouldn't be injured.
not if that's how you read the regulation. That is not, Your Honor, how we read the regulation, and I'm not sure how the FMC reads it that way either.
If we read it the same way the FMC reads it and holds in a published opinion, you don't have standing. It seems like you've basically gotten what you wanted.
On the business factors, Your Honor, you're right about that. On rate making, if I can go back, the commission in its brief and here today said, look, this is just one permissive factor we may or may not consider. That's really just downplaying its statutory overreach here. And the FMC has made clear that these rate factors are, in their words, critical and significant. So the inverse is also true. Under the way that the FMC has structured the rule, our reading of the rule, rates could be the only factor that the commission considers to find unreasonable, and carriers would be left without any recourse there. And lastly, Your Honors, there's a theme throughout the FMC's brief and also mentioned here today, which is Congress gave the FMC broad authority because to adopt a rule to address serious supply chain concerns. But Congress's direction in this rule was clear, it was narrow, and it was simple. Define the term unreasonable. Here's what Congress didn't do. It did not reinsert the authority for the FMC to regulate ocean carrier prices. It did not remove the core purposes of the Shipping Act that the FMC regulate with minimal government intervention. And it did not give the FMC the ability to depart from past precedent without reasoned explanation. So we ask that the court vacate the rules rate-making export policy provisions that exceed the authority in the Act, and at a minimum ask that the court remand the case back to the FMC to explain how each of these disputed factors are relevant to and would be used in any reasonable analysis.
Mr. McGovern, before you leave, is there any commission supervision of the tariff rates?
Tariff rates are publicly filed, and so that
Are they in any way constrained?
so that other than the requirement in the Shipping Act that they be publicly filed, they don't have any authority to determine tariff rate up or down.
And tariff rates, would you say still commonly the ones charged, or is most everything under service contracts now?
Your Honor, roughly speaking, it's about, my understanding is it's about 75% service contract, 25% tariff. But actually this gets to, Your Honor, this gets to the point that the commission has made. There are other comparable provisions in the statute. They're not comparable provisions. Actually, they're very different. And the ones that, the FMC has talked about, 4502, 41104, those are all just requirement to file a service contract, requirements that carriers adhere to their tariff. Those are general monitoring requirements, but the FMC doesn't have any authority to tell a carrier what it can and should charge in a service contract or a tariff because Congress never gave them that authority.
Thank you.
Thank you, counsel. Thank you to
Your
both
Honor.
counsel. Take this case under submission.
Court stands adjourned until Friday, December 12th at 9:30 a.m.